Testing 1, 2, testing 1, 2, 3, testing 1, 2, testing 1, 2, 3.
Let me know when you're good. If you need to call like a minute to settle in.
I'm good.
Good. Everyone ready? 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 Okay. The February 12, 2026 regular meeting of the Santa Monica Rent Control Board is called to order. Would the secretary please take the roll?
Yes. Commissioner Dudek,
Here.
Commissioner Gonska,
Here.
Commissioner Leslie,
Here.
Vice Chair Ambrose,
Here.
and Chair Ivanov.
Here. Please join me in the salute to our flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, item 5, approval of the minutes. If commissioners have had an opportunity to review the minutes from the January 8th meeting, may I have a motion for their approval? Commissioner Leslie?
I move that we approve the minutes.
Second.
Motion by Commissioner Leslie, seconded by Commissioner Gonska. May we have a roll call vote, please?
Yes. Commissioner Dudek,
Yes.
Commissioner Gonska,
Yes.
Commissioner Leslie,
Yes.
Vice Chair Ambrose,
Yes.
Chair Ivanov.
Yes.
Motion carries.
Item 6, special agenda items. Does the executive director have anything to report to the board?
Yes, and good evening, Chair, Vice Chair, and Commissioners. On Monday of this week, applications for the LA County Emergency Rent Relief Program opened for the first time to tenants. The program provides financial assistance to tenants and landlords who face financial hardship related to the 2025 Eaton or Palisades fire and windstorm events or any other emergency. Previously, applications were only accepted from landlords, but beginning this week, tenants who have been affected may also apply. If approved, funds are paid directly to landlords, and covered expenses may include past due rent or mortgage payments, eligible utilities, and other verified relating housing costs. Up to 6 months of rental or mortgage relief may be provided with a maximum award limit of $15,000 per unit. Applications will close on Wednesday, March 11th, and both tenants and landlords must complete their portions of the application to be considered. Interested renters and landlords can review eligibility requirements and apply at lacounty.rentrelief.com. That concludes my report.
Thank you. Item 7, public comment. This is the time set aside for members of the public to address the board on matters that are not included on the agenda, but are within the board's subject matter jurisdiction. Please note that the board cannot take official action at tonight's meeting on any matter not included on the agenda. I will call each person who filled out a speaker slip, and you should come to the podium and speak into the microphone when your name is called. If there is anyone who wishes to address the board during public comment who has not filled out a speaker slip, please see the board secretary. Our first speaker is Kay Arnold. And please put 2 minutes on the timer.
Probably less.
No worries. But you can use the full 2 minutes. Whenever
Good
you're
evening, members of the Rent Control Board. I'm looking for more information, parameters, what my rights and responsibilities are on the subject of having a shared utility meter with another apartment. It has been that way since I moved in. I have never paid utilities. They've always been included in the rent. Nobody has approached me directly, but I hear a lot of conversations from the apartment above me, also outside in the yard surrounding my apartment. and I'm a senior. I received Section 8 subsidized housing, and I've lived in my apartment for 6 years. It's rent controlled, and I noticed in one rent control board bulletin sent out maybe 2, 3, up to even 4 years ago or more, there was a blurb about about a shared meter, and I just wanted to know what my rights and responsibilities are in this situation. And I feel like I'm being harassed to death, to be honest. Thank you.
Thank you for your comments. Can we have a member of staff talk? Thank you. Do I have any other public commenters?
No.
Great. Moving on to item 10, jurisdictional items. 10A1 is an appeal. This is decrease case P 2024-5921. May we please have the staff report?
Good evening, Commissioners. Teresa Hausenbauer filed a rent decrease petition alleging water leakage, mold, and high humidity in her unit. And the hearing officer denied her petition because she found that Ms. Hausenbauer had failed to meet her evidentiary burden for those claims. She has appealed the decision. Ms. Hausenbauer argues that the hearing officer unfairly relied on evidence from prior to her submission of her petition, contrary to her instructions at the hearing. The record does not support this claim. The dispute around leakage and mold goes back to 2019 and includes a previously unsuccessful decrease petition to the board filed by Ms. Hausenbauer in 2019, followed by a civil lawsuit that resulted in an unfavorable jury verdict against Ms. Hausenbauer, so the parties could have provided potential evidence going back more than 6 years. But board regulations only authorize rent decreases for conditions in effect at the close of record, with retroactive decreases going back to the first rent due date after the filing date of the application. So the hearing officer appropriately urged the parties to focus their evidence to that time period, which was from approximately October 2024 to March 2025. The hearing officer clarified, however, that the parties could offer relevant evidence from before this period to show when a witness was last in the unit or when a repair was made. As detailed in the staff report, the hearing officer's denial of a decrease for the alleged conditions are supported by substantial evidence and are reasonably supported by the record. Moreover, in none of the findings denying the decreases did the hearing officer rely on evidence from before October 2024, except for relevant evidence provided by Ms. Hausenbauer herself. Ms. Hausenbauer also argues that the hearing officer should have made a negative inference against the owners for when they said they were not going to undertake any further mold remediation or investigate dampness in the crawl space. But Ms. Hausenbauer bears the evidentiary burden of proving her claims, and she failed to show that she was entitled to a rent decrease for either of these conditions. Ms. Hausenbauer also argues that she did not have an opportunity to review all of the hearings recordings before filing her appeal, but as detailed in the staff report, it was Ms. Hausenbauer who chose to file a timely appeal instead of a late appeal with a showing of good cause. Because the hearing officer's decision is supported by substantial evidence and reasonably supported by the record, staff recommends that the board affirm it and its findings of fact and conclusions of law.
Thank you. Does any commissioner have questions about the staff report? Commissioner Gonska?
Can you provide some additional context around allowing a appeal after the deadline and specifics to this case?
As you will see in the next appeal, people do file an untimely appeal on occasion. When they do so, the board can consider that untimely appeal if there is a showing of good cause. Of course, that's very fact-specific to each situation, and it's the board who decides whether there is a showing of good cause in order to consider the substantive portions of an appeal.
Any other questions? Okay, seeing none, I believe we have the tenant here, Ms. Hausenbauer. You can approach the podium. And you have up to 5 minutes whenever you're ready.
Okay. Okay. I had 3 complaints attached to this petition: water leakage, mold in the wall, and high humidity throughout the apartment. I hired 2 professionals to investigate these issues, and they testified at the hearing. Mr. Joel Berman, who's a certified industrial hygienist with Health Science Associates out of Los Alamitos, and Mr. Jeff Hughes, who's a forensic construction expert from Aperture Company, and he's based in El Segundo. In regard to the water leakage, Mr. Berman testified at the hearing that he did 2 inspections, and these were in early 2025. And in regard to the west dining room wall, he testified to visible mold damage, high moisture readings off this wall, and that the wall was soft to touch. When he came for his second inspection, a month later, it was about a week after we received rain, and he found 10 feet length of this wall to be completely saturated with moisture, the entire wall. Mr. Hughes, the forensic construction expert, he corroborated the same findings as Mr. Berman in regard to this wall. The hearing investigator made a report. She also testified, and in her report, she references, quote, water-like staining and damage observed on the dining room ceiling and wall, and she presented her photos and videos and her video at the hearing, and they would speak for themselves as far as the damage to that wall. In this decision, the hearing officer sets an unusual high bar of any witness actually seeing water pouring out of this wall. And I don't believe that's an acceptable standard in industry or one that a homeowner would use. In regard to the mold in the dining room wall, Mr. Berman observed mold growth inside the wall cavity. He verified this by video boroscope and moisture readings, and this is the high bar. This is the gold standard for identifying mold in the wall cavity. He recommended hire a construction expert to identify and fix the leaks, otherwise the mold is going to come back. He recommended mold remediation under controlled conditions so that the mold doesn't spread to the rest of the apartment, and he recommended that the entire apartment be boroscoped because he thought it was a bit overwhelming in there. In regard to the high humidity in the apartment, Mr. Berman reported mold throughout the apartment on furnishings, surfaces, as evidence of high humidity. His investigation concluded that the tenant was not at fault. He got high moisture readings off the wood floors in the living area and in a bedroom and off the wall in the bedroom. His recommendation was to investigate this crawl space due to a possible connection between this high moisture readings coming off the floor and the high humidity. Mr. Hughes, he also found these high moisture readings off the floor in the living area and the bedroom and off the bedroom wall. He too recommended crawl space investigation, and he took a look at all the vents underneath the apartment, and he found some of those vents to be partially blocked. And he also reported a violation of the Universal Building Code because of this being used as a commercial residence, and it has a dirt floor crawl space that if it doesn't have a vent in each of the corners of the building, then you have to place a vapor barrier or install a mechanical ventilation system in the crawl space. So this apartment is currently uninhabitable, and the landlord has since petitioned to raise my rent by $2,500 per month because I'm not living there.
Thank you.
Thank you.
Commissioner Gonska, do you have a question, or is that from?
No, I think, answer my own question. I think that there was a question in here in the staff report about filing late, but that didn't happen in this case, right? It was filed on time, and there was a revision to the appeal, right?
Ms. Hausen, we can't take any additional comment. Thank you. I don't believe we have any representative from the owner. Is that correct? Okay. Does any commissioner wish to begin deliberation or make a motion? Commissioner Dudek?
I'm curious to know why her rent is raised $2,500 a month.
Was that something that was in the evidentiary record? Because I don't think that's something
I
we
don't
can
think so.
consider if
I'm
it wasn't
sorry.
in the
That's
record.
right.
Okay, so that's outside the scope.
That's-
Is that you again?
Yeah, I never came out of the queue, but I do have a question.
Okay, yeah, Commissioner Gonska.
Or not a question, but a comment. I mean, I think some of the things that we heard tonight in the comments were different than what's in the record here. I mean, in particular, as it relates to mold, I think the record showed that there was mold found on personal property in a few instances, but that is not under our regulations a housing code violation, or it's not a housing code violation. It's not something that can be a rent decrease can be granted for. So I think if there are new conditions or new evidence that perhaps was mentioned here during the comment, that could potentially be part of a new decrease petition in the future if there's relevant information that wasn't included in this petition. But as far as what is in the record here, I don't see any error that was created or that was created by the hearing officer. So I would move that we affirm the decision and its findings of fact and conclusions of law.
Commissioner Ambrose.
Yeah, I have a question about the 6-month waiver recommendation, and just wanted to bring that aspect for discussion about why the waiver, what we feel about that, and whether that is also part of the motion. Just kind of want to discuss that aspect a little bit further. I guess I'll say more. I said, I guess I'll say more. So, in the comments, first of all, I did want to point out that there was a lot of discussion about the wall, the dining wall, the damaged wall. However, that was not part of the complaint or the part of the appeal. And in terms of what can be brought, that there are other repairs or other issues that the petitioner may bring forth in a separate complaint. And generally, it is our practice to have a 6-month waiting period. And so it was the recommendation of the hearings officer to waive the 6-month waiting period. And I'm unsure as to the rationale for that.
Is that something that staff can clarify?
So in the decision, the hearing officer has actually waived that 6 months already. And it looks like the reason is because she's allowing the petitioner the opportunity to obtain new evidence on these same issues. And she's laid out 3 issues that if new evidence comes to light that the petitioner can present, and that would be the water leak in the north dining area wall, the mold in the wall cavity, or persistent high humidity, those 3.
Okay, thank you for that clarification.
I believe we still have a motion on the floor from Commissioner Gonska. Is there a second from anyone?
I'll second it.
Motion by Commissioner Gonska, seconded by Commissioner Ambrose. May we please have a roll call vote?
Yes. Commissioner Dudek?
Yes, and the tenant does have an opportunity to refile according to this if with additional information and proof. So I think that's fair. Thank you.
Commissioner Gonska?
Yes.
Commissioner Leslie?
Yes.
Vice Chair Ambrose?
Yes.
Chair Ivanov?
Yes.
Motion carries.
Item 10A2 is an appeal of a tenant not an occupancy case 2025-00335. Before we go to the staff report, are there any disclosures on this item? Commissioner Leslie?
Yes, I need to disclose that I called counsel on this case. Just in regards to when was the appeal mailed out. Nothing further.
Are you recusing yourself from the vote, or are you still?
No.
Okay. Thank you. May we please have the staff report?
Yes, Commissioners. Eric Linden, the owner of this property, petitioned the board to find that Ms. Hogg is a tenant not an occupancy under Regulation 3304 and increase her MAR based on recent market rents. Ms. Hogg doesn't dispute and didn't dispute that she no longer occupies the unit as her residence of usual return, as that term is defined in the regulation, but she has appealed the calculation of her new MAR. Ms. Hogg filed an untimely appeal, so the board has to first decide if there is good cause for considering her appeal at all. Ms. Hogg's counsel states that he filed her appeal 4 days late because he sent the appeal to an incorrect email address and didn't realize that the email had not gone through until 4 days later. He had also mailed the appeal, but he mistakenly believed that it only needed to be postmarked on the appeal due date as opposed to received in the office by the appeal due date. And therefore, those are the basics on which Ms. Hogg is asking the board to consider her untimely appeal for good cause.
Thank you. Does any commissioner have questions about the staff report? Commissioner.
Thank you.
Commissioner Gonska.
Yeah, so my question is, do we have, and I apologize if it's included deep in the staff report, but is there any evidence that was submitted of a screenshot or a printout of the email that was apparently sent with the wrong address?
Yes, the things track. The question is simply whether that's good cause. If you think that that's sufficient to show a good cause.
Okay.
Okay, and I don't believe we have any speakers on this item. Okay.
Yeah, but sorry, commissioners, you need to first decide whether there is good cause for me to continue to give you the substantive portion.
Yeah. So do we need a roll call motion? Or we can just. Okay. Okay. Do we want to hear this for a good cause or?
Yeah, I'm good with it, given the fact that they showed that they actually did send it to the wrong email address on time.
Okay. I agree with that.
All right. Substantively, Ms. Hogg argues that the hearing officer erred in the calculation of a new MAR. Under Regulation 3304, the new MAR must be based on the market rates for any comparable unit rented on that property within the last 3 years, but none were. So then the regulation states that the hearing officer must base the new MAR on the median rent for comparable units in the same city area that have had a market rate increase in their rent within the last 3 years, and that figure is $2,200. The regulation also allows for an adjustment of this rent based on several factors, if supported by evidence in the record, taking into consideration the principle of diminishing relative value, which the regulation defines as meaning that the disparity in amenities between units at some point doesn't further influence the value of the rent, for how much the rent is for that unit. The hearing officer found that the relative lack of renovations for Ms. Hogg's unit is a reason for adjusting the market rent valuation from generic studios in her city areas and decreased that MAR by $30 taking into consideration that principle of diminishing relative value. Ms. Hogg argues that the hearing officer should also have discounted the new MAR because of maintenance conditions in her unit. But she conceded that she had never informed her landlord of these conditions. The hearing officer found that while Ms. Hogg may get a further decrease of the MAR through a decrease petition, the maintenance conditions are not a basis for adjusting the MAR here. After all, Ms. Hogg didn't provide any evidence that the average studio in her area with a recent market rate increase lacked these or other maintenance conditions. She also argued that the hearing officer should have decreased her MAR further because her unit lacked amenities that are in other units on the property, such as an AC, dishwasher, new windows, and carpets and drapes, but the hearing officer didn't base the new MAR on the rents charged in the other units because none were rented within the last 3 years. Because the hearing officer's decision is supported by substantial evidence and reasonably supported by the record, staff recommends that the board affirm it and its findings of fact and conclusions of law.
Thank you. Does any commissioner wish to begin deliberation or make a motion? I would just note, this was already mentioned in the staff report, but some of the maintenance conditions that are discussed here, like a defective heater, defective kitchen flooring, although a decrease in the MAR through a tenancy not in occupancy petition may not be the proper remedy for that, it is possible that a rent decrease in the form of a rent decrease petition could be. And I'll just leave it at that. Commissioner Gonska?
I do have a question about the amenities, the absence of specific amenities in the staff report. The report reads that there is no evidence in the record that the average studio in the area with the market rate increase had any of those specific amenities that were pointed to. So is the burden on the petitioner to provide that evidence, or does a hearing officer do research and determine if that's the case?
We wouldn't have, the hearing officer wouldn't have that, because when people register their rent, they don't register what the amenities are, except for parking and pets, because those are specific regulations that require that. So the hearing officer wouldn't have that. So if to the extent that such evidence is available or exists, that would be something that the petitioner bears the burden of providing.
Yeah, I mean, this is something that's come up from time to time over my tenure on the board, where we've had tenant not in occupancy cases that are, personally, I don't love some of our regulations around how new MARs are determined. That said, that's my opinion, and there's a process to work through potentially changing those regulations, and I might pursue that. But as far as it goes, the regulations stand as they are today and during the period of this case. So I don't see any errors that the hearing officer made. I think that the regulations as they stand were followed. So I am in agreement with the staff recommendation.
Commissioner Leslie?
While my fellow commissioners might be in agreement, I think there's some things that need to be taken into consideration. Not here, but in a rent decrease, as far as the repairs and maintenance that the tenant made on the property. So I don't necessarily love this code either. It seems to be rather intrusive at times. And it doesn't take certain things into consideration as far as those that have suffered through domestic violence or other tragedies that come along with life. So as far as I'm concerned, I think we should just consider it and deliberate further.
Yeah. Are there specific parts that you want to point to?
Well, here in this letter that we just received, and I know we can't conclude on new evidence, just as far as the repairs that were made, I just think that that's something that should be deliberated later for a rent decrease. And sometimes we take these things in consideration when there is a rent decrease, and we haven't necessarily approached that since we've been on this board, as far as tenants that make repairs on their own when the landlords don't make these repairs, and how much of a rent decrease should they get?
So, but We're talking about an alternative remedy here, correct? So if it's not really our jurisdiction to be prodding anyone to file a rent decrease petition.
Commissioners, the tenant has been made aware of the fact that she can file a rent decrease petition, and my understanding is that she is considering doing so if she's not already done so.
Thank you.
With that, does anyone have a motion to make?
I move that we affirm the decision and its findings of facts and conclusions of law.
I'll second.
Motion by Commissioner Gonska, seconded by Commissioner Ambrose. May we have a roll call vote, please?
Yes. Commissioner Dudek?
Yes.
Commissioner Gonska?
Yes.
Commissioner Leslie?
Yes.
Vice Chair Ambrose?
Yes.
Chair Ivanov?
Yes.
The motion carries.
10B1, item 10B1, removals. This item is removal permit application 2025-05797-D. May we please have the staff report?
Yes, Commissioners, the Boys and Girls Club applied for a removal permit to have a developer demolish the 7 units on this parcel that they've owned since 1998 and have it be replaced by 257 new apartments that includes 26 deed-restricted units as required by the city. They propose to replace the 7 units to be demolished with 7 controlled units. The charter allows the board to issue removal permits for redevelopment of a property with new apartments if the permit is being sought so that the property may be developed with multifamily dwelling units, the permit applicant agrees as a condition of approval that the new units will not be exempt from the rent control law, and that at least 15% of the control units to be built on the site will be at rents affordable to persons of low income. As detailed in the staff report, the only large-scale developments, those with significant increase in the number of units, such as here, from 7 to 257, for which the board has approved a removal permit, were for 100% affordable housing units until 2013, when the developer of the Village Trailer Park applied for a removal permit. Unlike the 100% affordable developments, the Village Trailer Park was a market rate development that sought to replace 99 rent-controlled mobile home pads with 358 new apartments. In that case, the board approved the permit only after it required the developer to provide not 99, but 109 controlled units, a 10% increase in the number of control units and a third of the total new units, a requirement that was within the board's discretion. The board also required the developer to provide enhanced relocation benefits that gave the tenants of the 99 units the right to temporarily relocate to a comparable unit and then return to the project after its completion to a comparable unit, all at the same rent that the tenant had been paying plus the annual general adjustment increases. And last year, the board approved a second removal permit for a large-scale private market rate development, and in that matter, the board approved the permit with the same number of new control units as the number being removed, but also required the owner to provide tenants from the 10 occupied units temporary relocation to a comparable unit, and then to be able to return to a new comparable unit once the project was built at the same rent that they had been paying. This project is distinct from both of those large-scale developments. Only 2 of the 7 units are currently occupied at the time of the filing of the application, and the owner states that both of the tenants agreed to permanently relocate through a buyout agreement prior to the submission of this application. So the proposal does not include temporary relocation and the right of return at the same rent for the 2 remaining tenants on the property. It proposes to replace the controlled units with the same number of newly constructed control units. It should be noted that the recent changes in state law already require replacement of each of the control units, as explained in the staff report. In considering this proposal, the board's options include granting the permit as proposed, requiring additional control units, requiring the owner to provide a right of first refusal to the displaced tenants at the same rent that they're paying plus annual general adjustment increases, or to deny the application.
Does any commissioner have questions about the staff report? So for option 3 that we have before us when we're discussing our right of first refusal, would that only be to the two tenants from the 2 occupied units? In option 3 out of the 5 options that we have before us.
I mean, that depends on if they have information about the other tenants and why
Well, the other 5 of the 7 units are not occupied.
that's what we've been told, correct?
Okay.
Is it correct that we don't know when the labor last occupied?
Correct.
So my understanding is that we have 2 speakers on this item. Oh, sorry. Oh, I apologize. Commissioner Ambrose?
Can you just explain the law or whether or not it requires a 1-for-1 basis of replacing the rent-controlled units for a 1-for-1, or whether or not that's a calculation that we are bound by?
Sure. So the law says that the units that are going to be developed will not be exempt from the provisions of this article. So it doesn't specify a 1-for-1, and in fact, arguably, it requires all of the developed units to be covered. As explained in the staff report, state law at a minimum requires all of the current controlled units to be replaced on a 1-for-1 basis, but the charter gives the board broader authority.
Thank you.
Any other clarifying questions? Seeing none. So I have Kevin Kozel and Brynja Sigrin. I hope I'm pronouncing that correctly. You guys have a total of 5 minutes, so I don't know how you guys want to do it. If one wants to do 2 and the other wants to do 3, or Kevin wants to take all 5, that's fine. Okay. Sure. Whenever you're ready.
Good evening, Kevin Kozel. I'm appearing tonight on behalf of the applicant, the Boys and Girls Club. I want to start by explaining the property and the application because I think there may be some ambiguity. The Boys and Girls Club owns 6 lots along Lincoln in 2 parcels. One parcel has 5 lots. That's where the club's gym, main building, parking lot are located. There's a separate parcel that only contains 1 lot. That's the northernmost lot. That's on that is a building that has commercial space and the 7 rent-controlled buildings. What we're asking tonight is a removal permit for the 1 lot so that all 6 lots can be developed with the 257 units, 26 deed restricted units, and 7 replacement rent-controlled units. There's only 2 remaining tenants. Both have signed voluntary buyout agreements at generous amounts. In fact, I think one of the tenants sent you an email explaining they're happy with the club as a landlord. They're going to take that money, move out of the area and buy a home, and they are in support of the project. The Boys and Girls Club has submitted comments explaining how the sale of this property facilitated by a removal permit will help ensure its continued financial viability and its ability to provide much needed services to the city's youth on a nonprofit basis. Based upon the reports, there seems to be some ambiguity about the removal permit requirements. I've been practicing law in Santa Monica for nearly 40 years, since 1987. I've done a lot of rent-controlled work, worked on many removal permit applications. In fact, one of the staff reports cited in the board staff report from 1997 has my name on it. It's always been my understanding that the board's practice has been 1-for-1 replacement. In other words, if you have 7 units, you're going to, no matter how many new units you're building, the requirement is that 7 of the new units be the replacement units. Now, I'm not asserting that that's the only interpretation of the charter. And I'm not asserting that the board can't have a policy discussion at some time about changing its practice. But what I'm saying is that has been the historical practice, a 1-for-1 replacement. and I want to read, this is from the removal permit that I handled about 8 months ago. And this is a quote from staff in explaining that matter to you. The board has consistently interpreted this provision to mean that there must be an equivalent number of controlled units in the new project as are being demolished, thereby preventing a loss of rent-controlled units and replacing them with newly constructed rent-controlled units. So when the club has said that historically it's been a one-for-one replacement, I stand by that statement. Now, finally, I want to be really clear and direct about the ramifications of the board either denying this application or modifying it by adding additional conditions, which you haven't done in the past. The 7 existing units, controlled units in question, are on the northernmost lot. If you deny this application or add conditions, the most likely result is that instead only 5 lots will be sold, a smaller project will be developed, fewer deed-restricted affordable units will be developed, and the 7-unit rent-controlled building will remain vacant. It'll likely be used for something else and not developed immediately. And in fact, that is an option that the parties have negotiated in the purchase and sale agreement. In conclusion, we respectfully request that the board act as you did on the last removal permit application about 8 months ago, require a one-for-one replacement for the controlled rental units, and grant the removal permit. This will be a very significant benefit to the Boys and Girls Club and allow it to continue providing its services. Now, just one last point. If the board wants to change its practice going forward, we recommend that you schedule public hearings, you get input from the public, but we respectfully request that you don't change your practice on this application. Thank you.
I just had a question. I believe somewhere in the application, I believe there was a mention that if the board were to allow a greater than a one-to-one replacement, it would essentially be a financial burden that would disincentivize the developer from taking this project on. Could you provide a little more context or specificity as to why a greater than a one-to-one replacement would no longer make the project feasible or pencil out?
Well, 2 points. First of all, I don't represent the developer. I only represent the Boys and Girls Club. But I do understand that when a developer is looking at these projects, they pencil it out, they speak to lenders, and one of the things that lenders discount is how many units are under rent control. And if you start adding additional units under rent control, at my understanding, again, is that it makes the project infeasible. Now, and the point is that they specifically negotiated an option in the purchase and sale agreement that allows them to go back to the Boys and Girls Club and say, we're not going to buy the 6 lots, we're only going to buy the 5 lots. So that is an option that they have.
Commissioner Gonska?
Just on that last point, that's not something that's like an automatic trigger, right? It's just an option that they have. So it's a potential outcome that they could still move forward with developing both parcels, even with a modified removal permit, correct?
That you are correct. But we pushed the developer to try to come in with some compromise, and we were told they were not open to that. So all I can tell you is they do have that option. I do believe that the right for the tenants to return is probably more palatable than adding additional rent-controlled units. And I know you're not asking the question, but I do believe there is a rationale for why the board has always done a one-for-one replacement.
Just on that point, I mean, because you referenced that multiple times in your comments, that's the practice, but the staff report points to numerous examples of when that wasn't the case.
Well, I disagree with that, because what they pointed to is a number of cases where there were all affordable projects. And my understanding has been in the past that the board's position has been, for example, with Community Corporation, if you're going to get a project that's 100% affordable with all deed restricted units, that in the board's mind is a very good project, and the units don't have to be under rent control because you're getting deed restricted units. For example, with the 6-lot project here, there will be 26 deed-restricted affordable units under the city's requirement. If we go to a 5-lot development, there's going to be fewer. It'll be 23 or less. So,
yeah, and I would like staff's response to that if all the cases that you are aware of were only for entirely affordable deed-restricted units. But before we get to that, because you raised the topic about the number of those deed-restricted affordable units, one of the issues that I see here is that it seems to me there's a little bit of a double dipping going on where the city requirements, separate from the rent control, separate from the removal permit, based upon, I'm guessing, density bonuses, et cetera, require 26 affordable units. And this removal application is saying that of the 7 that will be replaced, 7 current rent-controlled units that would be replaced as rent-controlled units, 2 of those would be deed-restricted. So to me, it seems like you're double-dipping there because while they're still rent-controlled, the cost of those units under deed-restricted affordable conditions would be well below the rent-controlled MAR, which would be set at market rate when these new tenants move in. So is there an appetite there to separate those out, have 7, at the minimum, 7 rent-controlled units separate from the 26 that are deed-restricted affordable?
well, to be clear, it does get confusing because there is overlap, and I think both, like, for example, the city and the state recognize that, death by 1,000 cuts. So, for example, the city allows its AHPP units to also count as part of the state density units, so you don't have to do separate units. But in this particular case, what will happen, as staff has pointed out, if there are 7 replacement units, the charter requires that 15% of those be affordable, so that's 2 units. So of the 7 rent-controlled units, 2 will be part of the 26 deed-restricted unit. The other 5 will not be part of the 26. That'll be 5 rent-controlled units on the market units. And so, and the board's position, and correct me if I'm wrong, is that since those are vacant, first rent charge becomes the base rent, but those 5 market units will then be rent-controlled units, and the rent will be limited while the tenants live there.
Yeah, I mean, in my view, we're placing additional, right now we have 7 controlled units, and by this proposal, we're placing additional restrictions on 2 of those units. So it leaves us with only 5 that are of the same conditions that we currently have.
Well, you will get 7 rent-controlled units.
Good, but 2 of those will have further restrictions that will only be rentable to people of low income, correct?
Yeah, they will be, exactly.
That's a change from the existing structure where 7 of those are available under rent control to people of any income.
Correct.
So what I would like to see is that even though it may be allowable, I don't know if that's the case or not, but that's been reported tonight that the state allows, that's sort of in my language, a double dip. I would like to see that the eventual developer provides those 26 units separate from the number of rent-controlled units that are replaced. But can we go back to the question about what was asserted was that all the cases where the board hasn't required a 1-to-1 replacement were because the development as a whole was entirely deed-restricted affordable as opposed to any other sort of mix?
No, it's actually just the opposite. So the 100% affordable units are where the board has only required a 1-for-1 replacement. When we've seen the private developments, that's where we've seen some changes made. So for example, the Village Trailer Park, the board required more controlled units than were currently existing on the property. So the point is that this is not a one-size-fits-all proposition. There's no quote-unquote practice, as we've explained to Mr. Koza multiple times, but he doesn't want to admit that for whatever reason. The board each has to look at each application on its own merits, and determine what makes the most sense on that individual application. That is what the board is obligated to do.
Can I just respond?
I mean, we could.
That answered my question. I mean,
Yes.
I have a different question.
Sure.
Because I think this was also mentioned in the letter that's included, the letter from the Boys and Girls Club that's included in the staff report. Let me just get back to it here. There's a line that seems rather exaggerated to me. And I think this was referenced in your comments too. I mean, I understand your point about the two parcels and that in theory, one of them could be developed, and if we deny the permit, the removal permit, the other that has the existing units could remain or, you know, be developed eventually separately. But the letter says, if more than a one-for-one replacement of the controlled rental units is required pursuant to a removal permit, it'll jeopardize and most likely preclude any sale. That to me seems unbelievable. We're talking about 257 units here. Are you telling me that is the assertion that if one additional unit, rent-controlled unit above the 7 existing is required, less than 0.5% of the total units being proposed, that the whole deal is going to fall apart?
What I'm trying to, I'll be very clear. What I'm saying is the developer has the option that if the removal permit application as proposed is denied, they have the option of terminating the deal and going with the 5 lots. Now, and we did have discussions. We're thinking, again, in the Village Trailer Park, that's the only one that staff mentions that's a market rate project where more replacement units were required. And that's a very unique situation because there were 109 spaces. The developer came in, only wanted to replace 99. They weren't going to replace all 109. They had a development agreement with the city, through a lot of back and forth and negotiation with the staff, they agreed to do 109 to replace the 99, so basically 10% more. And I didn't represent that matter, but as I understand it, the deal was that of the 10 controlled units or spaces that weren't going to be developed, if they ever came back in to replace those, the board would agree that that would be a one-for-one replacement. But the point is, in response to your question, we were hoping that we could come in and offer something in addition to the 7, but we were told that that was not agreeable, and if more than 7 are restricted, then the developer has the option of terminating and going with the 5-lot development.
Okay. I think just to my fellow commissioners, I think as I stated, I don't buy that any additional requirement for additional rent-controlled units above the 7 would sink this deal. We're talking about a multi-million-dollar deal with 257 units, and they're asserting that if we just increase it by 1, the deal falls apart. I don't think that that's believable. I think that we should consider what, and the other thing that's different here is that I think what's really at stake is the price of the sale depending on what the circumstances are, depending if we put additional restrictions on here. I think it is believable that perhaps a new price that the Boys and Girls Club would receive could need to be negotiated, and perhaps it becomes less valuable for them. And of course, because it's a nonprofit that does great work in the community, that's something to consider as a valid point. That and at some point, if, for example, in my opinion, if we required all 257 units to be rent controlled, I do think that would sink the deal. So there is some level that I do understand and would encourage you guys to think through that would be too far, and I think it's well below 100%. I think that's a very legitimate market condition argument to make. But I think that there is room to require additional conditions here as you're considering what is for the good of the overall community, not just one seller, which in this case is a sympathetic seller, is a seller that does good work in the community and would put this money to great use. But nonetheless, there are other community considerations to consider too.
Well, my only pushback would be, even if you don't think it might sink the deal, the question is, are we willing to take that risk? And I think that's a different question. But Before we get into deliberation amongst ourselves, Commissioner Leslie, do you have a question for Mr. Kozel? Commissioner Dudek, do you have a question for Mr. Kozel?
I have a comment and a question, but the affordable, I have a question and a comment. The affordable units then are low income, correct? They do not include moderate income?
You know, I don't, Tom, I don't think so. I think they're low income.
Can I make a comment, or would that come?
Well, let's save that for deliberation. Does anyone else have any questions for Mr. Kozel?
I would give you the opportunity to respond to what I said, because we are doing a Q&A if you want to.
Yeah, no, thank you for that opportunity. And again, I just want to be clear. I'm not saying that if you change the conditions, it automatically will sink the deal. What I'm saying is the developer has that option. They've told us they'll exercise that option. And again, I think the rights for the tenants to come back is a more palatable position than increasing the number of rent-controlled units. And again, if you could just indulge me, I do think that the reason that there has been a one-for-one replacement requirement is that even prior to Costa-Hawkins, the board has a new construction exemption. So the thinking had always been, for example, if you had a 3-unit building and you could build 10 units, the owner could come in and build 7 new units. They would be market rate. There would still be only 3 controlled rental units. And that's why I think there's always been this understanding that if the developer came in and wanted to build 10 brand new units, only the 3 would be under rent control. That's why I think there's always been a one-for-one replacement. It's consistent with the rent control law, and it's consistent with Costa-Hawkins. And again, my final point is I just urge you to do what you did on the last removal permit for a developer, which was required on a 147-unit project, only require one-for-one replacement on the 12 existing units. And for the Boys and Girls Club, a long-standing nonprofit in the city, don't burden them with more than you did on the last application for a developer.
Just to clarify, that last application you're referring to, there were many other conditions that were placed on there. It wasn't just, and that would have been taken into consideration when determining the one-for-one replacement, that there were additional right to return, relocation benefits, et cetera, correct?
Yes.
You left that part out.
You're absolutely right. There were 10 existing tenants in that building, and those 10 were given temporary relocation and the right to come back. That's why I said, if you do any conditions on this, the right to return and the temporary relocation for the existing tenants would be much more palatable than adding additional rent-controlled units.
Okay, and then also just to clarify one other thing you said, that do you acknowledge, though, that you keep referring to the requirement for a one-to-one replacement, but do you acknowledge that the requirement is only that you can't do less than that? There isn't the requirement that you can't require more. Would you acknowledge that?
I will acknowledge, as your general counsel, Ms. Regan, read, the charter language is unclear. It is unclear. What I'm saying is that for years, the board has historically required a one-for-one replacement. In fact, this is from a staff report.
But again, I'll let you finish, but we haven't required it. We've required a minimum of one-to-one. You may be saying that, I think your point is that we've established a pattern that there's been only a one-to-one, but we haven't had that as a hard and fast rule that there's only a one-to-one replacement.
What I would say is there's been a consistent administrative practice of interpreting that section of the charter to mean one-for-one. In fact, from a staff report in 2017, the board's general counsel at that point said, since its consideration of the very first removal permit application, the board has interpreted Charter Section 1803-2 to require only that those units built to replace those that were removed be subject to rent control. That is a direct quote out of a staff report from 2017. That's the way the board has always interpreted that section. But I agree with you. The charter language itself is not crystal clear. And I, if the board wants to change its practice in the future, again, I think you should schedule public hearings and hear from the public and how that would be impacted by Costa-Hawkins and other laws. But please don't do it on this application.
Commissioner Dudek?
Yes, I did want to comment that in this particular case, the 5 or the 7 tenants who are accepting a buyout will not have a right to return at their current MAR. Perhaps they could come back at market rate. These units are going to be market rate. They will be on the market at market rate. Once the buyout has happened, they don't have the right to return at the last permit that we did grant allowed them to return at their market, at their rate, and and they gave very, very generous. There were some very, very generous. It was considerations made for those tenants. In addition, there have not been that many. It's not like we're. There haven't been that many removal permits in the history, and most of them have been. Weren't they mostly affordable? There's only been a couple. This is one of them that is on a commercial basis, but the one-on-one, one-for-one is a state law. That's not our law, as Commissioner Gonska said. That's a starting point. But it's my understanding in our law that we have several things we can consider in making a decision, and one is the overall impact on the rental market and affordability. And I have concerns about the moderate income that's not included at all, for one thing, and also that we'd be losing one, at minimum, one rent-controlled unit. And I think, we have an affordability crisis. We're all aware of it. So I'd like to look at that a little bit.
Could I respond just to kind of
Sure.
give some clarification? You're absolutely right. The 2 existing tenants signed voluntary buyout agreements at very generous amounts, but you could certainly condition this to require that if they wanted to waive those, they could be given, for example, the relocation benefits that the last removal permit application you granted. So that could be done. With regard to the affordability, the charter says that we have to make sure that 2 of the replacement rent-controlled units are low income, and that's being done. The affordability levels on the other units are state and city requirements, but from your standard, your charter, they have to be 15% have to be low income, and we will meet that standard. And again, if you don't approve this and the developer chooses to do the 5 lot, you're going to get a smaller project with fewer affordable deed-restricted units.
I do have a follow-up question on that last point. So while it's true that if there are only 7 controlled units, ultimately that the 15% requirement would result in 2 of those being deed restricted. But if you decided to do 10 rent-controlled units, that 15% would only mean 2, in which case we would have more than the current 7 that are regular rent-controlled units. So it's not a requirement that 2 of them have to be deed-restricted affordable. It's only the way that this is maths out because the proposal is to only replace 1-to-1 and have 7 units.
Correct. The charter says of the replacement units, 15% have to be affordable.
Is that so? Yeah. Can you help us understand that language of the replacement unit? So is that not how it's worded?
It doesn't say of the replacement units. So the language is of the controlled units, 15% of the controlled units.
So in theory, if there were 10 controlled units, only 2 of them would need to be deed restricted affordable.
If that's 15% of 10.
I'll take that. Well, it's 1.5, and you can't have half of it.
Okay.
Well, and 15% of the 7 is 2 because you round up.
Commissioner Leslie?
We've been all over the place tonight. So of the 257 that you propose to build, and we are here deliberating on 7, this is 7. So it is altogether should be approximately 38 altogether if you want to put the 15%. But if it was that, you're saying that the developer would back out.
I'm not sure I understand the question, but the project is proposed is 257 units. Under the city and state requirements, 26 of those have to be deed restricted affordable. So that's the city and state requirements. Then the rent control requirement is we have to have replacement rent controlled units. We're saying that there will be 7 rent controlled replacement units. Of those 7, 15% have to be affordable. So 15% of 7 is 2. So you're going to get, of the 26 deed restricted units, 2 are going to additionally be rent controlled units. And then of the remaining market units, you're going to overlay 5 of those with a designation as being rent controlled.
Well, I've heard you a couple of times say that, in the past it's only been 1 for 1, 1 for 1. But also you've also said that it's some ambiguity as far as how the policy is written. So either it's concrete or it's ambiguous. It's not both.
Okay, if I could explain, in the law there's this concept called contemporaneous administrative practice interpretation. So the charter amendment, as your counsel read it to you, is open to different interpretations. So the charter is open to different interpretations. But the practice has been to interpret it to mean 1 for 1. So whereas the charter may be a little bit ambiguous, the administrative practice, I believe, has been consistent 1 for 1. So the interpretation of the somewhat ambiguous charter language is very clear 1 for 1. That's what I'm trying to argue.
That's what your interpretation is.
That's my argument, yes.
Yeah, that's your argument. However, you know that each case is different. And it's at our discretion and not necessarily saying, okay, each one is definitely going to be this one. Each one could be different and different restrictions and different administrative things that we want to do as far as to make it equitable for everyone involved.
I agree. You have discretion. These are discretionary hearings. All I'm asking is that you be consistent in the way the board has acted in the past.
I don't think there is any consistency as far as how we've acted in the past because each case is different.
Well, I disagree, but you are the board commissioner and you have the discretion to make the determination.
Commissioner Gonska?
Something we haven't touched on is what was mentioned earlier in the staff report, I believe, was the conditions around the 5 vacant units and what the history is there, because we don't have records to show the last time that those were occupied. Can you provide any additional context around?
If I could ask Bill Dawson from the management company to come up.
Yeah.
My understanding is the 5 were voluntarily vacated over the years.
Yeah, I mean, I'm curious. Yeah, feel free to come up. My question is about when they were last occupied and the conditions around why those tenants left.
Good evening. Bill Dawson. I work for the property management company Sullivan Deturi. I've been managing this property personally now since the club purchased the property in 1988. Of the 5 units that have vacated, I looked up the information prior to today's hearing. All 5 voluntarily vacated over time. Unit 2 vacated in 2024, January 2024. This gentleman was from Texas. He moved in during COVID and vacated in January 2024, moved back to Texas. Unit 5, the tenant moved in 2007 and vacated in 2010, and the club has kept these units vacant. They weren't sure what to do with them, what the future held for the property. Unit 6, tenant moved in 2008, vacated in December of 2023. Tenant moved to a larger unit in the city. Unit 7, the tenant moved in 2007 and vacated in 2015. And that tenant was also a former employee of the club, and we had facilitated them living in the unit while they were an employee. That person found another job and no longer works for the club and moved out in 2015, and we'd kept that unit vacant since then. So all the units were voluntarily vacated.
Were there any incentives for or payments made to those tenants when they moved out?
None.
Okay.
Yeah, we didn't know what the future held, so as you see with those move-out dates, over time, we weren't sure what was going to happen, but we did not re-rent them, and there were no incentives. If the tenants wanted to stay at that point, they could have.
Including that former employee?
Correct.
Okay. All right, thank you.
You're welcome.
Does anyone else have any questions for Mr. Kozel? Okay, seeing none. As we begin deliberation, I just want my colleagues to take into account, we have an opportunity here to significantly increase our housing stock, increase our deed-restricted affordable housing stock, and do it in such a way where we're not decreasing our rent control stock in any way, and we're not displacing any tenants. And so I hope that my colleagues take that into consideration as they vote on this issue. Commissioner Ambrose.
Thank you. I am glad to see that we're going to be having new housing, hopefully if this goes through, and I think that it will. And I like to see this project move forward in our housing crisis. And as a board, we're obligated to scrutinize the long-term impacts to our community. First, I'd like to point out that the city's requirements or the state requirement for the 15% deed-restricted affordable on new construction is separate and is not part of our consideration for what we require for rent-controlled units. And also the one-for-one basis is not what we need to follow. I want to make sure that we are keeping our rent control housing stock, of course, but it's not just about the physical units or, you know, the roof and the actual buildings itself. It's also about the people inside them, the ones that are renting for the year, for the 10 years, but in the future, as those, especially as it's a new building, will continue to move forward. And we don't want to displace Santa Monica residents. I know that the comment was made that at least one of the two remaining residents or tenants that live there was very happy with their buyout offer, but will be taking that money and leaving, I think it was said, not in our city. So that's unfortunate to hear. We'll be having someone who was previously in our city no longer living here. And let's see. Going back to the point that Commissioner Gonzga was making about trying to strike a balance between having not the one-for-one, I'm of the opinion I would like to see more than the 7, and somewhere between 100%, of course, because I do want to see this project move forward. But I don't believe that adding 1 additional or 2 additional units that are under rent control would kill the project. And I do understand that there is always an option for a sale to not move forward. There was another point. And I'll come back to it, and we'll come back to that. Thank you. Those are my remarks so far.
Commissioner Gonska?
Yeah, I agree with a lot of what Commissioner Ambrose is saying there. I think that, as I stated during the question period, it doesn't sit well with me to have further restriction on some of the rent control units that we currently have. In my opinion, we end up in a different situation than we currently are, where at the very least, if the regulations of the one-to-one comparison is designed to make sure that we don't end up with new development that reduces the rent control stock in our city. And while the number of units would remain the same, the conditions of those units would be different, and they'd be restricted to low-income tenants only. And so we would be in a place where we have additional restrictions on some of our rent-controlled units. Lately in the last couple of years, fortunately, we haven't lost rent-controlled units, but historically we have. And so anything that changes the existing conditions of rent-controlled units in the city is of concern to me. I think what's at stake here, if we're responsible with any additional restrictions that we might put on this removal permit, is not whether or not the plan falls apart and doesn't happen, if the units happen or not. It's the value of the sale. And again, I am sympathetic to who the seller is and how the funds will be used, but our responsibility is not to any private entity, for-profit or nonprofit. It's to the community as a whole. And I do think that there's an ability here to shape this, to make it better for the community as a whole, and to not cause it to go away. I think this is a very valuable project, not only for the Boys and Girls Club selling the land, but also for the developer who's going to make a lot of money off of these market rate units. This is premium property in the heart of downtown Santa Monica, in a place where we've seen tremendous development over the last several years. And I do believe that this land will be redeveloped, that we will get the housing if we do it in a responsible way. I don't think that what is before us is the best that the community can get. And so I think, in my opinion, we should talk about what are the options for, first of all, what are the additional conditions we would like to see? And second of all, just logistically, what are the options for asking for changes? And just to clarify, in terms of the timeline, and I understand that there's a 120-day requirement that's coming up before our next meeting. So there's some logistical things we would need to work for, and we can ask staff to walk us through that if you guys are, when you're finished deliberating or asking questions.
So can we get on the record from staff whether a remand is possible, and if not, why?
So the charter mandates that a final decision has to be made within 120 days of the filing of the application, and that 120 days is up on March the 6th. So if the applicant is not open to your proposed changes, then you could decide how you want to handle that.
So remand is not an option?
Right.
Okay. Commissioner Ambrose?
Okay, yeah, I remember my point, and then I have another, which is, and I think this was, I'm restating what Commissioner Gonska stated, which is, there is a difference between deed restricted units, which are for those that are low income, and rent control, which is for everyone, which has no bearing on what your income is, and what Commissioner Dudek has talked about, which is, we're not considering the affordability crisis that is affecting everyone, not just low income, but also middle income as well. And then going back to what our options are, I think at the minimum, just because there's only 2 tenants that are still occupying units, even though that they've been offered the buyout, I think that at the minimum we should be providing them the right to first refusal, and to be able to come back to comparable units based upon their current MARs once the project has been completed. So I think that would be, for me, the very minimum for granting the removal permit, but I'd also like to see more than 7 rent-controlled units, especially given the fact that the 7 is, to use the words double dipping again, with the deed restricted 15%. So somehow I would like to see the number increased.
Commissioner Dudek?
Yes, I agree with that. I agree with what we've heard from Commissioner Gonska and Commissioner Ambrose with regard to increasing the amount of rent-controlled units. I mean, again, they are going to be at market rate. It is not as if they'll be at market rate, but they will be stabilized, and they won't increase at. They'll increase at a slower pace as time goes on, but I don't think anyway. But I am concerned about the overall affordability issue, in that moderate income is not being considered at all with any units. I mean, this whole project, of course, is market rate, including the rent-controlled units as well. They'll go on the market at market rate. And that we have the low income, but we have nothing included for moderate, which concerns me. I mean, I can't rewrite the whole thing, but that's a concern, and it's a concern in a lot of different projects. I think, yeah.
Commissioner Leslie?
With market rate units in the Lincoln Corridor going for as much as $10,000 per month, I think the very least we can do is increase the number of affordable units or rent-controlled units. And I'm actually in agreement with what has been said thus far. Not to say that we want the project to not be profitable for those that are making it, but at the same time to be able to benefit for our community, and also to make sure that our people can actually stay here in the city and not be priced out. This is our obligation that's before us right now while we're deliberating. So at the bare minimum, an increase of those rent-controlled units and the first right to refusal is just the bare minimum, at the very least, that we can consider as a whole.
So are we concerned at all about potentially walking away from 26 new affordable units, 250 something new units to our housing stock, at the expense of 3 more additional rent control units or 5 more additional rent control units, whatever number we come up with that we want to add. I think in an ideal, perfect world, you can always cherry pick a bunch of different conditions that you want to make it the perfect deal. But are we willing to take that risk? And I know some commissioners have expressed that, they don't think one additional, 8 rent control units instead of 7 or 9 rent control units instead of 7 would blow up the deal. But the question is, are we willing to take that risk and walk away from this project? Commissioner Leslie? I'm sorry, Commissioner Duda.
Go ahead.
Sorry, she was in the queue for.
Well, I think that we, at minimum, should have the 7, at minimum, the 7 rent-controlled units. And
I agree with that, absolutely. We're bound by state law by that. I think we're all in agreement that at the very least we want a 1-to-1 replacement. I very much agree with Commissioner Ambrese's comment that I would like to include a right of first refusal to any tenants that have accepted a buyout. That is a condition that I'm willing to add to this. Go ahead if you want to finish your thought.
Well, yes, that, I remember that was my point. They have received a generous buyout, and it's their option if they want to take it. But I think it would be, if we want to include a condition that they would have a choice, but not necessarily replace, because they may choose the buyout over staying, but I agree that I would like to see them have that opportunity to take the buyout or to have the right of return at their MAR.
Yeah, it may be a very different calculation for people who decided to take the buyout if they have the option to return, because when they decided to take the buyout, that option wasn't on the table.
Well,
So there's all kind, I'm agreeing with you. There's all kinds of conditions for why somebody would decide to take a buyout. And if there are new conditions, I think they should have that option to reconsider.
From what we heard tonight, though, there's only two. I thought all five, all had taken the buyout,
Not just
but
two.
it looked like there's only two,
That's right.
because the others moved out earlier and they did not rent. So there's two involved. And I think I would be in favor of giving them the option of one or the other.
Absolutely. Commissioner Leslie?
So as we deliberate, I want you to take in consideration, it is not our obligation to negotiate the deal for the developers. That's not what's before us. That's not our obligation. It's their obligation to negotiate that deal with the buyers and the developers. Our obligation here is to consider what's best for our community and to make sure that we have more affordable units at the bare minimum, to keep the rent control units that are there and available, and it's at our discretion to increase or keep it the same. That's what's before us, not to negotiate a deal for them, for the developers. That's not what our obligation is.
I absolutely agree with you. Our obligation is to the community, and I think all of us agree that we're in a housing crisis, we're in a housing emergency. We hear all those buzzwords thrown around all the time. Certainly, this project is not in any way going to solve that crisis, but I think we have an opportunity to make a dent in it. You mentioned, our obligation to affordable housing. We get 26 new deed-restricted affordable housing units, into our stock from this deal. So, that's also something to consider in terms of, if we're thinking about the community here. Commissioner Gonska, is that you in the queue? Or?
Yeah. The question was posed earlier about, are we willing to take the risk? I don't know if, sure, there's some risk. I think it's extremely low that if we're responsible with what additional requirements we ask for, that the deal will actually fall apart. I think we'll still get the development that's being considered with some small changes. I think this is, in any negotiation, you're not putting your best and last offer first. And I think that one other thing that you guys have heard me say consistently the entire time I've been on the board, running for the board years ago, was that I fully support affordable housing. I think that we need to be always looking out for developing policy that helps the least fortunate among us, low-income people. I've always supported that. I will always continue to support that. But one thing that I do have a concern about is the hollowing out of the middle class. And there aren't a lot of programs. There isn't a lot of attention paid to people who maybe are just above that low income threshold, but they're still struggling to get by. And we want to have, the whole point of rent control, one of the points of rent control is to have a diversity within our community in many ways, and that includes income level. And so we also don't want to end up in a place where we have only extremely wealthy people and only low-income people who are indeed restricted affordable units. So anything that cuts away at our controlled rental stock by putting additional restrictions on it is a problem for me, especially when there's an opportunity to separate those out and to still get the same number of affordable units that we have while maintaining at the bare minimum the number of rent-controlled units that we currently have. I think that's really important. One question I have for staff is, if we decide that we want to ask for additional changes here, what are the logistics of that given the timeline?
Well, the applicant is before you, so they have the ability to modify their proposal tonight at the meeting.
And they don't have do they have the ability to extend the 120-day timeline?
I'm not aware of any opportunity to waive that timeline, and so I would be hesitant to do that. I think if you're unable to reach an agreement here tonight, the cleanest thing to do would be to deny the application, and then they could resubmit and restart the clock.
In resubmitting, what does that timeline look like? I mean, obviously it depends on when the application is submitted again, but from that point forward, how long did it take to get to this point here tonight in the current application?
I mean, I guess it would depend on staff, but it would be the same timeline, but it could come back fairly quickly.
Do you know how long this
I mean,
one
I
took?
would defer to Haka on that question.
What was the application date here before?
The application was submitted on the beginning of November, and so we counted 120 days forward from that, and that fell on this, as you already were told, it was March 6th is the 120th day, so the last board meeting between March 6th was the February meeting, and that's why it's before you.
Okay, but I have a couple procedural questions as well. If somebody makes a motion and then somebody brings a substitute motion before there's a second, the substitute motion takes effect or gets priority and is what's heard first, correct?
So if there's a motion on the floor and the second, before there's a vote on that first motion, if there's a substitute motion, then the substitute motion is heard first, assuming there's a substitute motion and a second to the substitute motion.
Okay, and if someone makes a motion and the vote fails, can someone bring another motion, or is the issue done?
If the motion fails, then you're back where you started.
Okay. Commissioner Ambrose, I believe you're next.
Thank you. I believe we are all in agreement, if I heard us all, that we would all want the requirement of the right of first right of refusal, right? So I think we can just kind of check that part off. The 1 for 1 or the 7 that is required, I think I'd like to just kind of revisit what that definition is, because I think we've sort of I think we need to look at that definition when we were considering what is rent controlled and what is classified as rent controlled and considered in the calculation and considered defined as rent controlled and affordable rent controlled or deed restricted. So I think if we can first decide what 7 is, just rent controlled, and if we can just decide that 7 means 7 that is not part of the 15%, we can start from there. But I'm inclined to look at looking at the village property where we used, which is within our discretion, we required more. I think it was 10%. And I would like to start with something more than 7. So I'd like to see where my colleagues are with something like that. 1, finding the definition of 7, and then 2, see where everyone is at with requiring a percentage more than that. If I have anyone's support on that.
Commissioner Dudek,
I think the requirement for 7 is a state law. So that's a starting line, as you said, Commissioner Gonska, that's a basic starting line. But our requirements in our charter allow us a lot more leeway than 7, than state law or even, the city requirement, that is a requirement, and they've met those two, they've met that requirement. But I just want to know, I keep mentioning middle income, and I don't hear any conversation about that. Are we considering asking for some units for the middle income? Or is that for another conversation, another time? In general, I mean, this group is so left out and cannot afford, they cannot afford the market rate, most, and so they can't live here. And there's nothing, it's not being addressed.
Commissioner Ambrose?
I also share that concern. I think what is within our jurisdiction and what we can do for the middle income is preserve rent control, which is a form of helping those of all income levels, including middle income. And that's why I think it's important to have as many, including the 7, defining the 7, and in fact increasing 7 by some percentage. And that would be the way to address the middle income, because having a, let's just say generally 3% increase versus having a regulated 3% increase versus having no rent control protections from our city is something that most, I would assume, renters would want. So I think that would be our best bet in addressing that.
Commissioner Leslie?
I'm going to take my name out of the queue.
Okay. Well, so I mean, I'm hearing from some of my commissioners that they would like to increase the, go greater than the 1-to-1 than what we're bound by state law. I mean, does anyone have any proposals of what they're envisioning? Because I mean, I feel like we're arbitrarily just throwing numbers around here. I don't know what we're basing that on, besides the fact that I mean, I understand that we have this authority under our charter, but how do we arrive at a number that makes sense, aside from just arbitrarily throwing it out, 10 or 12 or 15? So for the commissioners that are in favor of something like that, I would like to hear some more specifics of what they're envisioning and the basis to justify that increase or that number. Commissioner Leslie?
The number I'm looking at is 10, 3 additional units. That's not, a whole lot. That's not, the basis where we're like, okay, that's going to take away a lot of profit. It's reasonable.
Commissioner Gonsko?
Part of what I was meant to ask when I was asking for staff about what the logistics are of changes is because I don't have any information about the math of this for the seller, for the developer. So I'm not in a position to throw out a number and be a party to the negotiations. I think I would prefer to hear from the applicants here. So what does that look like? Can we bring them back up to respond to what this conversation has been? Because obviously I think we want to come to some resolution here tonight to give direction if we are not going to approve it, which obviously is an open question if we will or not. But in my opinion, it would be helpful to hear from them. So can we bring them back to get reaction?
Sure.
Would the other commissioners be amenable to that at this point in the conversation? No?
No, that's fine.
Oh, okay.
Yeah, that's fine.
Fortunately, what we've been told by the developer is that they want this application to proceed as proposed. They're not here, and I don't have any kind of negotiation authority, so I'm sorry.
One question for you is if our option is if we decide to deny the permit and there's a requirement for a new application, what impact does that have on the current deal that's before you, or just the process in general?
Well, at that point, the developer would decide whether they wanted to refile or if they just wanted to do the 5-lot application, 5-lot project, and not seek a removal permit.
And do you have any information on what the Boys and Girls Club would do with the other parcel if the developer moved forward with the parcel that does not currently have any housing units on it?
My understanding is it would probably remain vacant. It is in a commercial zone. It could be used for something besides rental units. It could be Ellised, and they could seek an occupancy permit from the city for a different use.
Okay, thank you.
Are you in the queue? Are you in the queue?
No, I just was.
Commissioner Ambrose?
Thank you. To respond to Commissioner Leslie, you threw a number out, and thank you for doing that, as 10, and I'm supportive of that as a starting. If anyone wanted to go higher, I'd consider that as well. But I do support that number, but with the condition of that 10 being 10 rent-controlled units that are separate from the 15%. So that the 15%, sorry, I'm looking at the staff report here that lists the numbers. Give me one moment. Okay, so we have here, there's going to be 1 studio affordable rent controlled, 1 2-bedroom affordable rent controlled, 5 studio rent controlled. So that would mean 7, right? So I would like to see 10 rent controlled, no affordable, and then it would still be, the 15% would still be applicable because that's law. And I would like to see 10 just plain rent controlled. Does that make sense? Yeah.
So I think the requirement is that we can only grant a removal permit if 15% of the controlled units are deed restricted affordable. So if we wanted, so I think I'm not going to speak for you, so tell me if you agree with this, but if we required 10 rent controlled units, then that would mean that 2 of those would be deed restricted affordable. So if what you said was that you wanted 10 that were not deed restricted affordable. So if that's the case, we would need to have we'd need to have whatever number it becomes, maybe 12, for example, controlled units, so that the 15% requirement got you to still having 10 that weren't. And that might be a potential outcome, but what I was getting at was that, and I think you agree, that the 7 that exist today that are not deed restricted affordable, we shouldn't drop below that. So if that's the objective, then you could achieve that objective by having 10 controlled units, of which 2 are deed restricted, and then in that case it would be 8 that weren't. Or I guess you could have 9. You could have 9 controlled units and have 2 that are deed restricted and 7 that are not.
That might meet what I'm looking for, but then we'd also have to look at the breakdown here, because it's also broken down by, let's see, there's 5 studios that are rent controlled, and then 1 studio that is rent controlled and affordable, and then 1 2-bedroom that's affordable rent controlled. So if we were to change the numbers, we also need to look at the makeup of which ones that we're looking at, which ones we're changing.
I mean, it sounds like from the comments that they're not interested in adjusting the proposal. So if that's their stance, what are our options here?
So what you can do, some of the options were laid out in the staff report. So you could grant the permit application with these conditions as you laid it out. They can walk away. They don't have to accept that. So, you could either deny the permit outright, accept the project as is, or put additional conditions on it, if you'd rather do that. So that is still an option for you. Whether or not the applicant accepts that is up to them.
So,
So what I'm proposing is permissible.
Sure.
Yeah.
Commissioner Dudek?
Yes, I'm okay with keeping the 7 and plus adding whatever it takes for the deed restricted. And also offering the 2 people the option of taking the buyout or the right to return at their MAR.
What do you mean by adding more deed restricted?
Well, I guess that would make it so that we keep our 7. We don't lose anything, and then you have to have 15% on top of that to make your.
But
so you
So it would be like,
increasing the number
I'm
of
saying
controlled
what I'm
units
saying
in
what
order to
he was
get
saying.
to- Is that what you meant? Instead of changing the number of affordable, you'd be changing the number of controlled units in order to get the 15% to mean that.
I'm saying what you were saying, that we do not lose any rent-controlled units, and that anything required, such as the deed restricted, would be above the 7. And that's it. I think that's quite reasonable. And giving the people the opportunity to have their choice of a buyout, which they might take, or the right to return.
Okay, so I just want to make sure I understand correctly. Because there's going to be 7 rent control units regardless in any proposal. We're not losing rent control stock in either scenario here.
Well,
we're not losing it, but it would be, I think, are you
they're
referring
being
to,
changed.
they would be, 2 of them would be changed from the current.
yeah,
condition.
that's
what she's trying to avoid.
saying, don't want to change. I want the 7. I would like to see the 7 standing as they are.
Which, as a practical matter, would require additional
Yes.
controlled units in order to.
Yes, maybe 2 more. In order to, just as Kay said, Commissioner Andrews, to meet the 15% while not losing we're not going down to 5. We'll keep the 7 intact. That's what I'd be happy with.
So would that be 9 rent control units instead of 10 under that proposal?
It could be, yeah. Are you finished with your comments, Commissioner Dudek?
Yes, I think I am.
Okay, so I think what I would propose actually is we're negotiating here with ourselves, first of all, and we're negotiating without very much information about the dollars in this deal. I mean, we've heard from one party how they've classified what the other party that we haven't heard from would or wouldn't do, but we're not privy to that conversation. I'm not suggesting that they're misleading us, but we can't evaluate that for ourselves because we're only hearing from one party. What I would suggest is we deny the permit and let them come back to us with an altered permit that works for them based upon what they understood from this long conversation tonight about what we're basically looking for. In my opinion, which might be different from others from what I'm hearing tonight, while I agree with generally the principle of right to return at the current MAR and not restricting currently rent-controlled units to affordable, that's like real small potatoes. And we don't even know the sale price that they're negotiating. I don't think. Are they talking about 50 million, 100 million, 300? We don't know. It's going to be a big number. I mean, you're talking about 257 units in downtown Santa Monica, some of the most premier land in the country. So let's not negotiate against ourselves. Let's not negotiate without very much information. Let's not. I think we should let them come back to us. They understand generally the principle we want. I think they should talk to the developer, figure out what the developers actually, because remember when they talked to the developer before and they told them that they may back out or they whatever, they didn't have our perspective. The developer didn't at that point in time. So it's a different reality now. They understand where we're coming from. They can watch, if they're not watching now, they can watch the video recording of this meeting. They can have an understanding of what our position is from everything we've talked about tonight. And they can look at the dollars and cents and decide what actually works for them if they want to move forward with this proposal, which I'm confident that they will want to move forward with this proposal. So I'm not in a position to say they will, that they can only afford 2 more additional rent control units. The reality might be that they can afford 20 more affordable units and still make this work. We just don't know. So rather than giving exact numbers right here tonight, it doesn't seem unreasonable to me to deny the permit, let them restart the process. I don't know if there's a way to, if they have to go back in the queue, I don't know if there's a way to expedite that. But the maximum would be another 120 days. So we're only talking about 3 to 4 months, depending on how the calendar falls.
Are you making a motion on that front or still just deliberating?
Not making a motion yet.
Commissioner Ambrose?
I like that line of thinking, and so then I will go ahead and make the motion, which was option 5, which is to deny the application for all the stated reasons that Commissioner Gonzaga has said, and hopefully we can come back with another proposal and with the same line of thinking here, which is, really we're just looking for something a little bit more. And this is all for the benefit of our community in the future, and we want this to be a win-win for all parties involved. So that's my motion. Thank you.
I second that.
I'm going to make a substitute motion that we grant the permit with no changes except for adding the condition of a right of first refusal for the tenants that have accepted a buyout agreement.
Commissioners, may I get just... No.
Is there a second?
Yeah, is there a second to the substitute motion? Seeing none, so the original motion is back on the floor. Can we have a roll call vote, please?
Yes. Commissioner Dudek,
Yes.
Commissioner Gonska,
Yes.
Commissioner Leslie,
Yes.
Vice Chair Ambrose,
Yes.
Chair Ivanov.
No.
Motion carries.
Item 12, administrative items. The next item is a report of an automatically adjusted rent decrease valuation guidelines. May we please have a staff report?
Yes, thank you, Chair. Let me just find my notes real quick. There we go. In 2023, the board amended Regulation 4200H to update the way rent decrease valuation ranges are maintained over time. Rather than requiring periodic board action, the regulation now provides for automatic biennial adjustments beginning March 1st, 2026. The purpose was to prevent valuation amounts from becoming outdated and to ensure that decreases remain proportionate, both controlled rents and current market conditions. Under the regulation, the 2 ends of the valuation range are adjusted differently. The low end of each range is increased by the combined total of the board's annual general adjustment percentages over the prior 2 years. For this first adjustment cycle, that is 3% for 2024, plus 2.3% for 2025, for a total of 5.3%. The high end of the range is increased by the percentage change in median market rents for new tenancies over the same period based on the agency's year-end reports. That change is 6.1%. Those percentages are applied to the respective ends of each range and rounded to the nearest whole dollar. Those changes can be reviewed in the red-lined regulations in your staff report. These adjustments occur automatically by operation of the regulation. No board action is required. The updated ranges apply to petitions filed on or after March 1st, 2026. That concludes my report, and I'm happy to answer any questions.
Commissioner Dudek?
I'm sorry, I didn't turn it off.
Oh, no worries. Commissioner Gonska?
Thank you for that report. I think, if I'm not mistaken, this is the first time that we're having the automatic changes to these decreased petition ranges, correct?
That's correct.
Yeah, so I just want to, I think this is great. This was how we designed it, because to solve a problem that had occurred over the past, I think, roughly 20 plus years, these ranges had only been changed twice, I think. because it required somebody to realize that they hadn't been changed in a while and decide to do it. And so we as a board put the automatic changes to occur every 2 years, and this is the result of that. So I'm very happy to see this.
Does anyone else have any questions or comments about the staff report? My understanding is that no board action needs to be taken on this item.
No
so-
action, but there's an announcement requirement in the regulation, so it'll come back every 2 years.
Okay. Okay, moving on to item 16. Can I have a motion to adjourn the meeting to the next, to our next regular meeting of the Santa Monica Rent Control Board on March 12, 2026?
So moved.
Is there a second? All in favor?
Second the motion.
All in favor?
Aye.
Commissioner Dudek, you're still in the queue.